Welcome and thank you for joining the second session of Seyfarth's webinar series, Understanding Corporate Governance and Internal Investigations. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Greg Markell. Greg, you may begin.
Thank you. So first I will introduce myself and Sarah Fedner. So Sarah Fedner will introduce herself. My name is Greg Markell. I'm a partner at Seyfarth Shaw in New York. I'm head of litigation in the New York office and co-head of national securities litigation. I'm a trial lawyer. I've done lots of major trials, and kind of an avocation that has arisen over the last 6, 8, 10 years is corporate governance. And I am the chair of the Center for Corporate Governance at the New York County Lawyers Association, which is an 8,000-member bar association in New York City. And I have started doing cases and other kinds of representations in the corporate governance area during that period. But I have a broader practice and do a lot of securities litigation. Let me turn it over to Sarah for a moment to introduce herself, and then I'll come back on.
Thanks, Greg. My name is Sarah Fedner. I am a senior associate in the litigation department. I work out of the New York office. I am a member of Seyfarth's Commercial Litigation Group, Securities Litigation Group, and ESG Group. I am also the New York representative on Seyfarth's Litigation Associate Advisor Committee. I would say about 60% of my practice, maybe a little bit more, relates to internal investigations in securities litigation, and the other 40% is general commercial litigation, whether that's in state court or federal court. And I believe Greg has a short introduction before we get into the slides.
I do. And so I want to talk just for a minute or two, literally, about what we're going to talk about today. So internal investigations can be done by a wide variety of people, but large internal investigations in substantial corporations often are such that they require board involvement and oversight. And so the question is, how do you make it efficient to have a internal investigation that is large, probably complex, be done efficiently and also consistent with the duties of board members, the duty of loyalty, the duty of care, the duty of oversight. And an efficient and useful approach that has arisen over the last 8 or 10 years is to use a board committee. A board committee can be an existing committee, it can be a new committee. But the board committee, by using the committee, there is much more efficiency and saving of time and money by handling it with the committee rather than the entire board, which is often hard to congregate except at regular meetings. This program will be full of practical tips on how decisions relating to issues that come up in the internal investigation run by a committee should be made. And it will also give best practices for that board committee in running those investigations. And now I want to turn it over to Sarah, and we'll get started with the meat of this overall presentation, and she'll be talking about a corporation and board authority.
Yes, so I will start with just a little corporate governance background on how can the special committee even be created and delegated authority. So in general, the board of directors of a company has the ultimate authority and power to make decisions on behalf of that company. The board of directors also has the ability to delegate this authority on certain issues to committees of the board, or perhaps specific officers who may be overseeing a certain line within the business, for example, the chief compliance officer. But they have the right to delegate some of this decision-making authority. They don't have to delegate, but in some cases, which we're going to get into, it may make sense to delegate this authority. And delegation extends beyond just creating a special committee to perform an investigation. It can be a delegation of certain topics the board is required to oversee, but that is beyond the scope of this presentation. The delegation to a special committee needs to be approved by the majority of the independent directors of the board, and that delegation should be described in writing. And Greg will get into this a little bit later, but the delegation should include a specific description of what is being delegated to the special committee and what is their authority. We'll go to the next slide, please. So what are some situations where a special committee should be created? By way of background, there are two main types of special committees that a board can create. For today, we are going to be focusing on special litigation committees, which focus on threatened or actual litigation. But there's also special committees that can be created by the board of directors to oversee certain transactions. So the board can create some sort of deal committee, transaction committee to, for example, oversee a merger or acquisition, something of that nature. Again, that's not within the scope of what we're talking about today, but it does exist. For today, we're going to focus on these special litigation committees and when it makes sense to create them. So there's a few common scenarios where it makes sense to create a special litigation committee. The first is when there's some sort of government investigation or government action against the company. The government has flagged something with the company, and it may make sense for the company to simultaneously perform its own review and investigation of the allegations being made by the government. It may be helpful for the company to look into what are the strengths of the government's claims, how much risk are we really facing here, is there anything we can do to improve controls or policies or procedures to show the government that we are taking this seriously, we've taken affirmative action, and we've already implemented these changes while the government action or investigation is going on. So that's one very common scenario where it may make sense to create a special litigation committee. Another scenario is where allegations are raised internally. So for example, by an employee, and then it trickles up to HR or the general counsel. There may be some sort of allegations of fraud. There may be some whistleblower claims, potential antitrust violations, corporate waste, things of that nature. In that case, it also makes sense in a lot of situations to create a special committee to investigate these allegations, to see whether there's any merits to the claims, is there potential liability to the company, and whether affirmative disclosures need to be made to regulators. In a third scenario where it may make sense to create a special litigation committee is where there are allegations of wrongdoing made externally by someone other than the government. So this is usually shareholders when there's some sort of demand letter by a shareholder that the board look into something, or there's some other shareholder-related lawsuit, it may make sense to create a special committee to perform an investigation or generally oversee ongoing litigation with these external parties. And again, a shareholder demand letter, that's a very common situation where it likely makes sense to create a special committee to investigate what's being alleged in the demand letter and respond to those allegations. Sometimes the board can investigate these things on their own. For example, if the entire board is independent, which we're going to talk a lot about later, theoretically, the entire board could perform the investigation, but a lot of times these investigations are extremely time-consuming, and it may not make sense for the entire board to be dedicating a substantial amount of their time to this investigation when there's a number of issues, especially at a big company that the board is responsible for overseeing. It may make sense just from a resources standpoint to delegate this issue to a special committee, so not every single person's time is consumed as much as those on the special committee are. And with that, I'll turn it back over to Greg.
Thank you, Sarah. I'm going to talk about the business judgment rule, and many of you know what that is. Many of you have also heard the term business judgment rule, but it's very important that the business judgment rule be kept in mind when you're doing a large, complex corporate investigation. And there are ways in which you can lose the benefit of that rule, so we're going to lay this out to some extent as background for later slides, which will refer to the business judgment rule. So what is the business judgment rule? The business judgment rule is something that has developed and become effectively law that in almost every state, if not every state, recognizes. And it's a legal presumption. And the presumption is that it will protect directors and officers, and by protecting the directors, that means it's protecting special committee members from claims of wrongdoing if they acted in connection with an issue of an investment, a declining an investment, a merger. In any of those situations, if the directors and officers kept themselves reasonably informed, acted in good faith, and had an honest belief they were acting with lawful and legitimate interests of the corporation and its shareholders in their mind. And before I go on a little bit further on this, let's talk about why that came into being. There essentially are two reasons. One of them is that there could be a tendency for directors to be sued or officers to be sued every time something goes wrong. So you make a decision to get into an aspect of business, or you buy some assets, or you buy a smaller company, or you merge with someone. If those things are done in good faith and a belief that they're in the interests of the corporation and the shareholders, even if it turns out that they didn't work out, that whatever the issue was, whatever the judgment was, whatever the activity was, if it just because it doesn't work out, it is not in the interests of the economy overall, the country, certainly the directors, if they can be sued because they made a mistake, honestly. And one of the things that some of the issues that we're going to take up today takes into account is the fact that it's important to have people who are well versed in running corporations be willing to serve on boards, so that boards are run by people who have some idea what they're doing in running that business. If people could be sued simply because some judgment that they made was wrong, if that were sufficient, then it would be very hard to get people to serve on boards, and it would be very hard for insurance companies to insure them in connection with D&O insurance to protect them. There's another reason, however, why the business judgment rule is in effect, and that is because many judges have, in their own opinions, recognized that they don't know as much about business judgments and how to run a corporation as business people do. There may be some exceptions to that in the world, but generally that is the case. And so judges are reluctant to come to a conclusion that a decision made, a judgment made by an officer or director to take a certain action in business is somehow correctable by a lawsuit. So those two reasons, the fact that you want to keep being able to recruit strong directors, and that judges really don't know often a great deal about how businesses should be run, the business judgment rule has arisen, and the business judgment rule is there to protect directors who, again, are acting in good faith in an honest belief that they're doing the right thing. And therefore, courts afford great deference to board actions taken by independent directors who are reasonably informed on the issue in question and act in good faith. It is a rebuttable rule. In other words, just saying, well, the business judgment rule protects me no matter what, doesn't work, right? And so it can be rebutted if it can be shown that the directors breached a fiduciary duty by engaging in self-dealing, made decisions that are tainted by conflicts of interest, and we'll talk a few different times about conflicts of interest, which are really frowned on by the courts if they exist in people who are just making decisions about actions for corporations. Acting fraudulently, dishonestly, or in bad faith, or in violation of the various fiduciary duties of directors, then you can rebut the business judgment rule. But you need something like that. Really, a lot of it boils down to acting in bad faith. Then you can defeat the application of the business judgment rule as a plaintiff. If those things don't exist or can't be shown, the business judgment rule will protect directors and officers in lawsuits. So moving on to the next slide. So if there is a decision to create a committee to do something such as do an internal investigation and other things as well. It could be, as Sarah mentioned, there are special committees that are for things like evaluating acquisitions and mergers. We're not going to get into the details of that today, but a lot of the things that are going to be mentioned in terms of how to appoint the special committee would also be covered by in that other type of special committee. And number one, the size of the committee. I think a lot of people think that the preferred size is 3. It's not absolute requirement. It is, but it's a manageable number. It's getting 3 points of view into it. It's making it easy to call meetings. You don't want 2 members if you can avoid it, and you don't want 4 members if you can avoid it, because that means you can have deadlocks, and you can do a lot of work and get nowhere if there's a deadlock on the committee. And so 3 is a much better number. 5 is fine, although it's getting a little on the large size for it to be an efficient committee, but 5's okay. You don't want an even number like 6. So because again, you don't want deadlocks, and so 3 or perhaps 5 would be the preferred numbers on the committee. The next slide in connection with that slide, Sarah is going to talk about the importance of the independence of the members, let's go back from. I'm going to mention the fact that in selecting members, you want someone who is independent, and what you'll find it means when Sarah talks about it is there are people who are not employees of the corporation and are not impaired, whose judgment whose judgment is not likely to be impaired by their other relationships within the company. But I'm going to let Sarah go through that in detail and with correct in all respects. If independence is going to be very important in running a special committee throughout the rest of the slide deck, and so it's important that it be brought up. It's also important when creating the committee that you select independent members. Sarah has already mentioned this, but it is essential that you have people who are willing to make a significant and adequate time commitment if there is a complex issue for the special committee to deal with. And one of the things that makes it efficient, as I mentioned earlier, efficient and a useful way to approach things is it's in general easier to get 3 people together for a committee meeting than it is to get a board meeting scheduled on short notice when an issue comes up. That's one example of why it's more efficient to use the committee. As in many things in life, in my opinion, good judgment and here the ability to make difficult decisions is essential. And so when one is trying to pick the people, effectively elect the people who are going to be on the committee, you want people who don't fly off the handle, that don't shoot from the hip. You want people who are thoughtful and have good judgment once they've thought things through about what is in the interest of the corporation. The next item is useful but not essential. If the members of the committee happen to be articulate, it is an advantage. There is always the risk at some point down the road there will be a deposition or trial with respect to their behavior as members of the committee. If they're articulate, that's a plus, but certainly not required. What is required is a lack of personal interest in the outcome of whatever issues are going to be covered by the committee. This goes back to the duty of care and loyalty, but it also goes back to conflicts of interest. There is no point in forming a committee to decide how to move forward with an internal investigation, or for that matter, with an asset purchase or sale, if they have a personal interest in the outcome of whatever is being reviewed and decided, it becomes almost indefensible to say that committee's judgment, recommendation, decision, it has any value if the people are conflicted and have an interest in how the committee comes out. The person also ought to be an independent board member. And now I'll turn it back over to Sarah.
Thanks. So I'm going to get into, in a little bit more detail, why is independence so important and what exactly does independence mean? What is the legal definition of independence? So we've both mentioned independence multiple times. It is probably the most important factor in considering who to appoint to the special committee. And that's for a couple of reasons. The first is, as Greg mentioned, the business judgment rule. So if the special committee members are not independent, any decisions that they make or conclusions, the court is not going to give business judgment deference to the special committee if any of those special committee members are lacking independence. When the court gives you the business judgment deference, you're more likely to successfully move to dismiss the case. It's more favorable to the company overall if you can get that business judgment deference, but it goes out the window if the people involved, including special committee members, are lacking independence. The second reason independence is so important is more kind of common sense. It goes to the credibility of that special committee in general, and perhaps, settlement discussions. So if there's special committee members who are interested in what's being investigated, they reach a conclusion, they make a settlement offer to the other side's not going to take them as seriously or believe their conclusions if those special committee members do have some sort of interest in the issue at hand. So again, the business judgment rule, you can lose that if there was no independence, and also just as a practical matter, it's hard to perform a thorough, independent, unbiased investigation if a committee member is somehow involved in the allegations. So what does independence mean as a legal matter? In September of 2021, the Delaware Supreme Court issued a decision reiterating the standard for independence. And the name of that case is a mouthful, but in case you're interested, it is United Food and Commercial Workers Union and Participating Food Industry Employers Tri-State Pension Fund versus Zuckerberg. That case involved demand futility, independence in that situation, but the standard articulated in that case also could apply to independence of board members and independence of special committee members. So the standard that the court set forth in that case looked at both each individual director's independence, whether they personally were independent, and also looked to whether or not they were under the control of somebody who may be lacking independence. So the standard the court set forth in that case in terms of whether or not someone was independent is, first, whether or not the director received a material personal benefit from the alleged misconduct at issue, or whether that director faced a substantial likelihood of liability on any of the potential claims at issue. That's the first part, the director's personal involvement. The second part in evaluating independence is whether or not that director lacks independence from someone who received a personal benefit from the alleged misconduct that was subject to the investigation, or someone who would face substantial likelihood of liability on any of the potential claims. So both, is that director independent in terms of whether they received a material benefit or they're facing liability, or are they under the control of someone who received a material benefit or is facing liability? There's a two-part analysis. I would look in your jurisdiction in terms of case law to determine whether or not someone's considered under the control of somebody else. There's a lot of case law analyzing this issue even before the 2021 decision. So I would look into, what constitutes being under the control of somebody else and when can that inhibit the independence of a director. As just kind of a general matter, being named as a defendant in a derivative lawsuit alone without more is not enough to show lack of independence. The reason why I bring this up is a lot of times when a shareholder files a derivative lawsuit, they're going to name every single board member on the board at the time of the filing. That does not mean that nobody on the board is independent and nobody on the board can serve as a special committee member. Instead, you have to look at, are there specific allegations or implications for each director that really ties them into this case or claims that would inhibit their ability to act independently. The fact that they're just named as a defendant and the only allegation against them is that they are a board member, that's not enough to show that they are lacking independence and cannot serve on a committee. Next slide, please. So independence is really important to consider not only when you're creating the special committee, but also throughout the course of the investigation. You want to maintain that independence so the committee's judgment isn't called into question at some later point in time because, for example, they had a conversation with someone who was involved, or it seems like they were under the control of someone who was involved. So one way to really protect that independence is to limit communications as much as possible between special committee members and those outside of the special committee. You want to kind of create a wall almost to stop those communications. There may be situations where it's important for the special committee to speak to people outside of the special committee. For example, there may be like some personnel decisions that need to be made, or there may need to be some changes to policies or procedures, or the special committee may just generally need to give an update to the board on what's been going on. In those cases, it's really important for the special committee members to consult with their counsel and figure out what's the best way to communicate these issues with preserving independence. And beyond independence, it's important to kind of wall off these communications because you also want to protect the privilege of the communications that the special committee members are having with their counsel. Greg's going to get into a little bit more detail about how to protect privilege. But again, independence, you want to consider it when choosing who's on the committee, and then you want to focus on maintaining independence throughout. Greg, I'll turn it back over to you.
Thanks. So the next slide deals with the scope of authority. So the way a board is created is through action by the independent directors of the board. As we've already covered that. There should be a resolution created that the board adopts, and that it's quite an important resolution. And what we've found over some years working on large investigations, and I mean by we I mean Sarah and I, you sometimes have to go back to the resolution to look whether a certain issue that has come up is within the authority given to the committee, and so you need that in writing. It has to be clear what was approved by the board for the committee to do, and that appears in a resolution. It could also appear in addition in a letter or to the committee members or to or in other documents from time to time. But the key place it appears and something that guides the committee throughout its life is the resolution creating it. And so, number one, it's going to talk about whether or not there is a authority to make decisions, or whether the committee is just formed in order to make recommendations to the larger board group that is independent for the board to act on the findings of the committee. And we'll come back to the findings of the committee in a couple of moments, but this has to go into the scope of the scope of the authority. You have to tell the committee what they're expected to do and what they have the authority to do, which is to either make a recommendation or to take action based on their findings. The resolution should also cover the types of issues to be investigated. In other words, the committee is not necessarily given the authority to investigate all sorts of different things that might come up in a corporation, particularly a large corporation. There has to be some effort to describe what it is that's being investigated. Sometimes that's pretty easy to do. In the case of a demand letter, the demand letter tells you what the plaintiff's theory is, plaintiff's lawyer's theory is. You know that the investigation is, if it is for the purpose of responding to a demand letter, you know the areas and can put it into a resolution that the committee should investigate. Sometimes it will be approved in the scope of authority, not only something specific, but it may also provide that the investigation can cover related or similar behavior without specifics. So, one example would be looking into a misbehavior by a senior executive with respect to employees. You might see a resolution that says, look into the investigation of John Doe for misbehavior relating to X and Y. It may also say, and similar behavior and similar actions. And then the committee's scope is a little bit broader in that circumstance. The resolution, of course, should mention the names of the committee members that have been denominated for the committee, and there are a number of other related things that related to the investigation or that should be in there, should be in that resolution. So, for example, the authority to hire experts, the authority to spend money on legal fees, the authority to engage in interviewing board members or audit committee members. There are all sorts of things that you want to make clear that the committee has authority to do or doesn't have the authority to do within the realm of what might be thought about in a internal investigation. Let's move on to the next slide. I'm not going to spend a lot of time on this slide. It'll be relatively brief, but first of all, this can be in a big investigation, and Sarah and I spent over 4 years on one of the investigations we did. The committee members met 32 times over that time period. Did other phone call meetings, and had to read materials that were provided to them. So it was a lot of time, a lot of work for them, for the committee members. It is not uncommon for there to be compensation paid to a committee above and beyond board fees for work that they do in connection with the committee. It should not be excessive. It should be kept in line with the fees that are paid to other committees by the corporation. You don't want to make it seem suspicious that this committee is getting a large amount of money. A judgment is necessary here by the people approving the resolution, and in terms of coming up with what it would be a reasonable amount of compensation. Sometimes the nature of the investigation changes. It expands. It contracts. More often expands than contracts, and compensation may be justified to increase the compensation. Generally, if possible, it's desirable not to change the compensation in the middle of an investigation, and the reason, if you can avoid it, sometimes it can't be avoided and it's dealt with in the normal course. But why should it be avoided if you can, doing it in the middle? Because you don't want the committee's good faith questioned. You want the committee to be as pristine as possible in terms of of the perception of their honesty and the fact that they're doing this. They're only interested in just the facts, right? They want the facts. They want to find out what the facts are, and then they want to reach their conclusions. That should be the perception of a committee in an ideal world. And so you don't want raises being made in the middle of an investigation where the people raising it might have something to do with some of the issues. It doesn't look right. The perception is bad. So if possible, you try and come up with a good compensation plan early, and if possible, you wait till the end to adjust the compensation. Next slide. Independent experts. It is often the case, not always the case, that a committee needs advice from an expert, just as a board does. And when we did our first session of this series, we talked a lot about the fact that boards could, and in fact, in many cases, should rely on experts. The same is true of a board committee. The committee may, if the issue is complex or technical, they can retain forensic accountants, economists, engineers, cyber experts, other subject matter experts. It is useful if all those people are independent from any relationships with the board and management prior to being retained for this purpose. One thing that is extremely important is the retention of legal counsel, and until you live through one of these, it's hard sometimes to understand why that is so important and why that should be everybody's goal. First of all, there's this perception issue with experts generally. It would also apply to counsel. Are they doing the right thing? And so typically, the regular outside counsel of the firm should not be retained to do a complex internal investigation of substantial size. They ought not be retained because there will be perceptions that they have developed relationships with management over time and board members over time that will affect the judgment of those counsel. Whether or not true or not, that perception is a problem. So typically you're looking for independent legal counsel who don't have a history of working with the company extensively. And there's case law out there where plaintiffs have attacked conclusions of committees simply because the counsel for the committee had a history of being very close to the company. And the counsel for the company do typically do a lot of the day-to-day work. The decisions should all be made by the committee, but the counsel are doing a lot of the day-to-day work. They assemble a lot of facts for the committee, and they need to be independent. They need to be free from bias, and in order to have credibility that will pass muster in the courts, that this was a truly independent investigation and the conclusions reached were reasonable. And now I will pass back to Sarah for the next slide.
I'm going to get into some of just the logistics of how do you conduct the investigation now that the special committee has retained independent counsel. Where do you even begin? So one of the first steps is to identify some of the relevant documents at issue in whatever is being alleged. A good starting point for this is to have special committee counsel speak with whoever raised the issue, or perhaps if it was in-house counsel who thought that an investigation was needed, special committee counsel should speak to that individual, see if there are any specific documents that may be important to the investigation and whether that individual has already been sent these documents and can forward the documents along to special committee counsel. It's possible that the company may have already performed some sort of document review or document collection before the special committee was created and special committee counsel was involved. So in that case, so for example, Greg and I worked on this large investigation that Greg mentioned. It spanned over a course of 18 years, so there were hundreds of thousands of documents. And by the time the special committee was created and we were appointed as special committee counsel, the company, who had retained its own counsel to perform a company investigation separate from the special committee investigation, had already collected these hundreds of thousands of documents, engaged contract attorneys to do some initial review, and then company counsel had done some further review. So in cases where there's already been some sort of document collection or review, like this case, you want to, special committee counsel should take a look at what was the scope of the collection and review of documents. Do you think it was sufficient? Are there any sort of issues or areas of documents you think there needs to be follow-up on? If there was review, is there any sort of additional searches you want to perform in the documents and review those documents? Again, do an assessment of what that initial document collection and review was. A committee is not required to recreate the wheel, so it would be extremely costly to collect all the documents again just for the special committee and then perform another contract review just for the special committee. The special committee can rely on efforts that have already been done by the company as long as there's evaluation of, was this sufficient? Is there anything else we need to do to make sure this process is complete? A lot of times, depending on how fast the investigation is going, document and review collection is being performed simultaneously with witness interviews. So you may not find a really important document until a couple of months later, depending on how long the investigation is, and you may need to go back to some key witnesses to ask about that specific document. So it's kind of an ongoing cycle of the document collection and the interviews at the same time. Again, as I mentioned, if there's a large amount of documents, it's okay to hire contract attorneys to perform those initial reviews. It doesn't have to be committee counsel if there's hundreds of thousands of documents who perform that initial review. Next slide, please. So witness interviews, I mentioned those. They could be going on simultaneous with this document review and collection. Same thing as with identifying additional documents. It may be good for special committee counsel to speak to whoever raised the issues or whoever knows the most about the issues to discuss who are good witnesses, who should we speak to first, who has any just general knowledge about what happened. Another good way to identify initial witnesses is if there have been key documents that have been flagged, for example, an email that went around that's particularly problematic, you want to see who was sent that email, and that's a good way to create a witness list. There may be some really important interviews, for example, of the person that you may think is most culpable, that should be saved until the end, just so you're able to get a handle of the facts before you speak to that really key witness to make sure you really understand the lay of the land. Special committee members are not required to attend the witness interviews. These are led by special committee counsel, but they can attend if they would like to. And in that large investigation, Greg and I worked on, the special committee members actually attended some interviews for the witnesses that were most important. And again, it was led by special committee counsel, but the special committee members did ask some follow-up questions where they needed some clarification. When you are conducting the witness interview, it's really important to have, in addition to the attorney questioning the witness, somebody there taking notes. When you start a witness interview, it is really important for the special committee counsel to give an upjohn warning. This is kind of like a Miranda warning in the context of internal investigations. If you do not give this upjohn warning to the witness, there's a potential that you cannot use anything that you learn during that interview later on. Upjohn is, the warning is named after a famous case, but basically what it requires you to do is identify yourself as, my name is X, I represent the special committee, I do not represent you, witness, personally. If you would like an attorney to represent you, you would need to retain your own attorney. And then also providing an explanation that the conversation is privileged, asking them not to share the conversation with others, but explaining that that privilege belongs specifically to the special committee, not the witness. So if the special committee decides to waive the privilege, that's their decision to make, and there's the potential that the special committee could do so and disclose what is discussed. Very quickly, you want to make sure that you keep notes or formal interview memorandum recording what was discussed. They should say that it's an attorney-client privilege, that it's not a verbatim recitation of the interview, and that an upjohn warning was provided. Greg, I'll turn it back to you.
Thank you. So next slide, please. Thank you. The next topic is maintaining privilege, and this comes up in a lot of contexts and relating to corporations. But some of them involve these committees. Some of those contexts, and so we're going to talk about how a committee can try to maintain privilege for what they are doing and what they are learning in the course of the investigation, and then later. First of all, the attorney for the committee needs to look at the privilege rules for relevant jurisdictions. It may be more than just one jurisdiction. It may be several. There may be witnesses in several. And so the council has to familiarize themselves with the privilege rules of the relevant jurisdictions, and then has to explain to the committee what rules apply and what the risks are, and what practices they should adopt in order to protect the privilege. The committee council should, throughout the process, whether the committee is in existence for 3 months or 2 months or 5 years, those do happen, as we know, and throughout that process, one of the things that is on council's mind is, am I doing anything that would put at risk the privilege nature of what the committee is doing, what they're looking at, what their conclusions are, and what their plans going forward are to complete the investigation. It is an ongoing process. And the other thing, actually, and this is not related to this slide, but I'll mention in a sentence or two. Sarah talked before about independence and the importance of independence. So the council for the committee should be thinking throughout the life of the committee whether anything that any committee action that is proposed, any committee inaction, whatever, is not going to adversely affect the privilege that they have at the start, and also not going to impair their independence. They need to preserve both independence and privilege as they go through the processes that Sarah's just been talking about in terms of witnesses and documents, and there are other things as well. There are meetings of various kinds. The independence and privilege should always be on people's minds, and what are the risks of doing X or Y or Z. Sarah covered the upjohn warnings. They are really quite important, and witnesses should be told to keep the discussions they have with council and/or the committee confidential. In our last session, we talked a good bit about some of these issues. The way to lose a privilege through a waiver is to have a third party have access to the privileged information. The upjohn warnings not only tell the witness who counsel is representing and that they can hire their own counsel, but also, as Sarah said, keep these discussions confidential, please. There's a risk of, if they don't keep those conversations confidential, and it's hard to enforce this point, that they might give the information to a third party, and there would be perhaps a waiver of privilege with respect to that information. To the extent possible, you want to ask committee members not to take notes, or at least any more notes than they absolutely need to take. The more documents that are created with other purposes in mind by committee members, the more likelihood that there are documents that may either be not privileged or that may be less than helpful at the end of the process if the process is attacked. So not creating additional documents is generally a good thing to not do if they're not necessary to do. The documents that are created by, should have disclaimers on them, and also should have notations that there are privileged, attorney-client privilege, joint interest privilege, that they are work product. That's not going to create those privileges or the work product doctrine. But it will help in protecting it over time if it's indicated that they are privileged documents. Sarah's already covered not disclosing information about the investigation outside the committee. That again is advice that the council should be giving to the committee. It's hard to enforce, but it should nonetheless be told to the committee, so at least it can be minimized. I think the last bullet point here is simply to tell everyone, privilege is a tricky area where you never know whether or not something is actually going to be found to be privileged, or seldom do you know that, and it's hard to predict in the future what might go on that might cause there to be a waiver of privilege, maybe on subject matter basis, and these documents might be subject to discovery, and therefore the committee members need to be careful about what they write and make sure they don't write unnecessarily, but they also, what they do write, they are careful about what that contains. I'm now we're moving along, and we only have a small amount left to do. Final recommendations. The committee, again, as I mentioned earlier, may be a committee designed to make decisions or a committee to make recommendations. In either case, they should report back to the board, at least to the independent board members, what they have found and what they have concluded and why they drew those conclusions. Once again, though, we're now talking about issues relating to preserving privilege, and there's a tension between the necessity to report back to I'll call it the full board. It may not be the full board if there are members of the board that would be problematical to have present, but let's call it the full board for now. If you're reporting back to the full board, you have to keep in mind maintaining privilege at that point in time, and trying to avoid anything that would be problematical if it were disclosed to a future plaintiff on some legal theory relating to securities or whatever. One of the things that a lot of major law firms do today relating to reporting on investigations is to do that report with a PowerPoint, which does not go into a huge amount of detail, but does record the fact that certain things that would be necessary for the committee to have acted in a way that was reasonable and sufficiently broad to do a good job. On the other hand, you can have too much detail, and it really isn't necessary for the report, and it may contain things that are problematical later on if privilege isn't maintained over the final report. With a PowerPoint, you can hit the main points and not necessarily put in a lot of detail. And what a lot of law firms are doing these days is after a report is made to the full board, they collect the PowerPoints and keep them in their possession. Probably shouldn't be destroyed, but they should be kept in the possession in a safe place, either in the possession of the outside law firm or perhaps the inside lawyers might have a safe place to keep it, but it should not be circulated around greatly because increases the risk that there will be a privilege waiver. And the report should, in any case, give an overview of work done, some of the key facts discovered, and the committee counsel's legal and factual analysis and advice about next steps. Sarah, you are doing the next one, which I think is the last substantive slide.
Yeah, just 20 seconds on this because I see that we're over. Whether or not a special committee is involved in remedial measures, say recommending new policies, making personnel decisions, initiating legal actions, or compensating a aggrieved party, that all depends on the authority that was initially delegated to the special committee. If the initial authority delegated to the special committee was, special committee, just look into this and make an independent report back to the board on what your findings are, special committee is not going to be involved in remedial measures. But if the delegation of authority is broader and includes considerations like personnel decisions, improvements to controls, et cetera, then the special committee can opine on and be involved in those remedial measures. And with that, I think we can go on to the next slide, which has the CLE code.
And that is SS 4877. So Sarah and I want to thank everyone for their patience. We hope that this has been useful in understanding the role of committees in guiding internal investigations, and we've actually enjoyed bringing this to you, but the important thing is it's been useful to you, and we hope it has been. And both of our emails and phone numbers are on the back page, which says thank you, and we say thank you to you all. But we also want to let you know that if you have questions on corporate governance issues more generally, we would be happy to help you to the extent we can, and we both have developed quite a significant knowledge on corporate governance issues. We are happy to answer your corporate governance questions if you want to get in touch with us. And with that, we're going to sign off. We know we're a few minutes late, but sometimes that's the way that works out. There's a lot of material here, and we tried to make it as fit within, as close as we could within the time allotted. So good afternoon.